call it. So to start this discussion, I will start with Professor Micheal Lynk. Micheal was the UN Special Rapporteur on Palestine. He was one of the first, or probably the first, to in an official position to speak about the illegality of the Israeli occupation in his report as the UN Special Rapporteur, as well as in some opinion pieces. One of them, you might find it on Egypt, on the criteria for an occupation to be illegal. So we're glad that finally the court has decided on this. What do you make of the decision, Micheal?
Thank you very much for having me, and thank you for your patience in enabling me to join this wonderful panel.
I think there is a technical issue with Micheal. Can you hear me, Micheal?
I can hear you. Can you hear me?
I can hear you, Professor.
So I see you are unmuted, but I can't hear anything.
Okay. Let me try again. Can you hear me now?
I can hear you.
Very good. Okay. Can you all hear me?
Yes, we can hear you, Mr. Micheal.
Let me ask again if I can be heard.
So, Professor Micheal, Saleh here. Can you hear me? I can hear you. Can you hear me?
Yes, I can. So maybe I can proceed.
Okay, so yes, please. I think maybe perhaps the others as well can. Maybe it's
okay.
Just Hassan. Yeah, go ahead.
Okay, so a great pleasure to be asked to be on the panel. I will keep my opening remarks brief because I know everybody else will have a lot to say as well. I think this is one of the most important decisions ever issued by the International Court of Justice. I think it was comprehensive in its answers to the advisory opinion that was asked of it by the General Assembly in 2022. I mean, the essential one-sentence story of this 80-page decision is, this is an illegal occupation which must end as rapidly as possible. And I'm taking from that it must end unconditionally, it must end as rapidly as possible, and it must end completely. In other words, Israel must withdraw in full to the 1967 borders. It must dismantle all of its settlements. It must make reparations to Palestine and to Palestinians for the economic and social harms done during the course of the 57-year-old occupation. And the only negotiations that can take place must be on all of the mechanics of a complete withdrawal. They cannot be negotiations with respect to how much land do we get to keep, how many settlements do we get to retain, how much control do we have over Palestinian territory. None of those issues are on the table. The only negotiation issues that can be on the table is on the mechanisms of a speedy and rapid withdrawal. So that's my opening review. I'm certainly happy to talk in more detail after the other panelists have made their presentations.
Thank you so much, Micheal. And apologies for the issue. I think the sound was great. It was an issue from my device. So I would like to hear what you make of this one, of this advisor opinion, Giulia. This decision has answered on questions related to unlawful occupation and annexation, obligations of the UN and United States, restitution, right of return, Oslo as apartheid. I would love to hear your general remarks on the decision before we delve into its specifics.
Thank you, Hassan, and thank you for having me. I absolutely agree with everything that Micheal said in its assessment that this is one of the most important decisions that was rendered by the court because it is so comprehensive. Not only it came to the conclusion that Israel's presence in the occupied Palestinian territory is illegal and must come to an end as rapidly as possible, but it also spelled out a number of ways in which Israel's policies and practices are in breach of international law. And I'll just mention a few just to give you the headlines, and then maybe we can go more in detail. The court reiterated some of its earlier findings in the 2004 Wall Advisory Opinion, for example, concerning the illegality of the settlement enterprise. But this time, because of the breadth of the question that was asked, the court was able to go much more in depth in examining the settlement policy and all of the ways in which it breaches international law. It also mentioned Israel's discriminatory laws and practices amounting to racial discrimination and apartheid. I think this is also a huge finding. And the court came to the conclusion that through its settlement policy and through a number of other policies and practices, Israel is acting as a sovereign in the occupied Palestinian territory. Basically, it's annexing part of the territory, which amounts to a prohibition, with a breach of the prohibition of the use of force and territorial acquisitions by force. So, huge findings by the International Court of Justice. And I think also what is important is that the court set out, like in very broad terms, a roadmap of the next steps. It is up to the UN General Assembly and the Security Council to establish the modalities of Israel's withdrawal from the occupied Palestinian territory. They must dismantle the settlements. They must provide reparation for the damage that they have caused. And the court also spelled out the obligations of international organizations and the UN in terms of non-recognition of the legality of the occupation and obligation not to render aid of assistance. I think this is the part of the opinion where perhaps the findings are a bit more general, but still is very significant, I would say.
Thank you, Giulia. I will ask the same question to Dr. Munir Nuseibah. Munir is the head of the Community Action Center of AlQuds University based in East Jerusalem. Munir is a leading Palestinian expert in international law, as well as he's very well known within the international legal community working on Palestine. Munir, being based in Jerusalem, listening to this advisor opinion, what do you make of this decision?
Thank you very much. I think this decision has been very important. I would maybe pick up a few things out of this decision. On the one hand, it has actually examined the effect of Oslo peace process on Palestinian rights in the occupied Palestinian territory. And it has clarified that the fact that negotiations have been going on Palestine does not mean that the rights of the Palestinian people on their lands, on their natural resources, their right to self-determination, as well as their right to be free of apartheid, are subject to questioning. And I think this in itself is a very important step forward in terms of the rights-based approach to resolving the apartheid situation and dismantling the apartheid and ending the occupation. So this is the first thing I would note. The other thing is that the court has examined apartheid as part of this decision. And this is, in fact, very important. There are, despite the fact that the question did not explicitly ask about apartheid, alternatively, it examined it asked about discrimination. But the court was obliged to find, obviously, because of all the facts that it has got from all the different submissions, that this regime is not only an occupation, is not only a colonial occupation that is building settlements, but it's creating a regime of segregation and apartheid. And this is very important, especially that apartheid is a crime in international law. There were other crimes that also this decision has referred to, building settlements, displacement of civilians, and many other issues. Finally, what I would argue is a very important element in this decision is that it has not only determined what the responsibilities of Israel as an occupying power is, but it has also reminded us of the obligations of the international community, and it has named international organizations generally, but named explicitly the General Assembly first, and then the Security Council. I think this builds for us a working program for the future. We have to now work with the General Assembly, especially. Obviously, we know our problems with the Security Council and the veto power, but with the General Assembly, I think there's a lot that we can do right now in order to ask the General Assembly and demand from the General Assembly to act upon its responsibilities. It has asked a question, it got the answer. Now it's time for action. And action here means sanctions until every element of illegality that was mentioned by the court in this decision, and many others that have not been mentioned because they were outside the scope of this advisory opinion, until they are over. So this is the important, most important from my point of view, point in today's advisory opinion.
Thank you again, Munir. Proceeding with our next speaker, Saleh Hijazi. Saleh is one of the leaders in the Palestinian BDS movement. He's the coordinator of the Apartheid-Free policy in the BDS. Saleh, I want to ask you, especially because of your experience with the BDS, now this decision has reinforced so many principles and so many standing points that the BDS has worked very hard to establish and was actually attacked for establishing them. What do you make of this decision, and how do you think this decision can change the situation and boost the Palestinian struggle to recognize and achieve the rights?
Well, thanks, Hassan, and Law for Palestine, everybody. This is indeed a historic ruling. It finds Israel guilty of apartheid. It finds its military occupation as unlawful. That is carried out annexation and calls for the dismantling of colonial settlements, for Palestinian refugees to return to their homes, and also lays out the legal consequences, the obligations on other states as well as the UN. Now it is the time that we put the pressure on states to see justice through. Justice is not going to come from The Hague. It's going to come from people taking action through boycotts, through campaigns for boycotts, divestments, and sanctions. Now we want to see states impose sanctions on Israel because of its flagrant and systematic violation of international law. Remember, this is the second ruling by the same court, the International Court of Justice, the highest court in the world, in the case of Palestine. Earlier in January, the ICJ found Israel of carrying plausible genocide in Gaza against 2.3 million people there, the first live stream genocide that is ongoing as we speak. It is the third such ruling after the 2004 also ruling on the apartheid wall. What we need to see right now is states acting on their obligations and people around the world who've been carrying out inspiring solidarity actions of targeting complicity with Israel's regime of settler colonialism and apartheid to maximize this pressure so that we could see justice and freedom in Palestine but also elsewhere around the world. Again, historic, Israel guilty of apartheid, its occupation unlawful. States must now take action or render the whole system of international law as meaningless.
Thank you, Saleh. I will proceed with Giulia, considering that she'll be leaving sooner than the other speakers. Giulia, apologies, I forgot to introduce her. She's a leading expert in international law. She has a working experience with the international tribunals, and she's a lecturer of law in Leiden University. So, Giulia, I wanted to ask you about the absence of the Gaza blockade and the question of the blockade in the decision. Do you think it was included in the between the lines, or do you think that the court has statutory limitations preventing it from tackling this issue?
Thanks, Hassan, for raising this important issue. First, I will say that one of the ways in which this decision is important, in my view, is because it recognized that the Gaza Strip is occupied by Israel despite Israel's disengagement. Now, we probably, everyone in this event agrees to that, but it's something that legally is widely contested. And I think recognizing Gaza as occupied territory, like even if Israel has no boots on the ground, but this assessment is based on the exercise of authority, which they obviously do, I think it has important repercussions also in the contentious case of South Africa versus Israel, because essentially it kills, in my mind, Israel's self-defense argument, because the court has already established there can be no self-defense when the threat comes from occupied territory. Having said that, it is true that the court, at least based on the summary that was read today, I still haven't read the opinion in full, doesn't mention Gaza's blockade. In a way, I think it was to be expected, because there was nothing specific in the question that prompted the court to look at the blockade. Obviously, they could have done so, but having worked at the court myself as a legal officer, I know that the court will not address any issue unless it's prompted to do so. And the question that was asked by the General Assembly, I think, had many merits, because it was carefully crafted, and it invited the court to pronounce on many facets of the occupation. But there was nothing specific on Gaza and the blockade, and I think this just the court sees the opportunity not to say anything on that. That's a shame, because they could have, but I think many of the findings, the more general findings about Israel's policies and practices, still apply to Israel's policies in the Gaza Strip.
Thank you, Giulia. Towards you, Micheal, and I see your microphone is open as well. I would like to ask you the same question as well about the Gaza and the blockade, but also about the practical question that comes after this advisor opinion. I did not read the full text, but I listened to the whole thing. I'm not sure I hear the word sanctions. There was talk of obligations that Giulia mentioned. There was talk of the obligation to not recognize or reject and different set of obligations. How should this be read in terms of let's say, punitive action as a responsibility for the UN, for third states, in case Israel continues to violate what the court has called unlawful? And this is very expected, that Israel will not respect this the same way they did disrespected the other decisions.
Indeed, I can't think of a single UN resolution or a ruling from the International Court of Justice, either in 2004 or 2024, where Israel has complied with the direction of the UN or the rulings of the International Court of Justice. So I can assume that Israel will already be taking a lighter and torching this particular decision, saying it means nothing, and it has no indication that it will obey anything that's in here. So what the court said with respect to, if you like, consequences and accountability, it said that all states are under the obligation not to recognize as legal the situation arising from Israel's illegal presence in the OPT, nor to render any aid or assistance that would maintain that particular situation. It made the same ruling with respect to the United Nations and all other international organizations, that they're under an obligation not to recognize as legal Israel's unlawful presence. But it left the big question as to what is to be done to the General Assembly and to the Security Council. Specifically, what it said is that the United Nations, particularly the GA and the SC, should consider the precise modalities and further action required to bring an end as rapidly as possible, Israel's unlawful presence. So yes, that puts wind in the sail of those who are called for boycotts and sanctions and divestment with respect to this, because there's no other way that is going to raise the costs, raise the stakes so high that Israel has to change course. And that means primarily we're looking at North America and Europe for civil society action and for ultimate political and diplomatic action with respect to that, because it is the trade, military, and diplomatic relations that Europe and North America have with Israel that primarily allow Israel to escape virtually any costs with respect to the maintenance and deepening of its occupation. Only when those kinds of sources of support wind up eroding and ultimately ending will this occupation be reversed. So for those, I think, who are arguing now, we have to take concrete action. It has to come from the United Nations, but more importantly, it has to come from individual states that say that they respect the rule of international law and say that they respect decisions coming from The Hague, both from the ICJ and the ICC, to put pressure on this. And the one last thing I'll say, and this may be a discussion point for us a little bit later on in the hour, is that I think the ruling of the ICJ today will give more backbone to those at in the prosecutor's office at the ICC. There's many complementary statements made in the ICJ's ruling that will, I think, embolden the prosecutor of the ICC in terms of his valuable work trying to determine violations of the Rome Statute.
Thank you, Michael. Based on this, I would like to ask you, Munir, about the priorities of the Palestinian legal struggle following this advisory opinion. Michael mentioned that this advisory opinion can be the basis for action by the UNGA, the United Nations General Assembly, and the United Nations Security Council. But what should be the Palestinian priority in advancing this? This resolution recognized the apartheid violations, maybe without quoting the apartheid convention, but quoting CERD, which is it almost serves the same purpose. It spoke about the right of return without, I think, specifically limiting the mandate. It talked about the Oslo Accords. What do you think?
I believe that our priority now should be on pushing for sanctions within the UN General Assembly, and of course the Security Council as well, but mainly the General Assembly. The reason behind this is that we now have our legal our legal framework laid out by the International Court of Justice, the highest court in the world in international law in general. And because of this now, we have all the legal tools to argue, at least in terms of the territory occupied since 1967, that this occupation is illegal, all settlements are illegal and should be dismantled, that the regime is an apartheid regime. We know that many countries have been resisting this despite all the evidence that has been advanced. Professor Lynk, your mic is on and it's giving some background sounds. Thank you. So it has actually laid out also that we are under an apartheid regime, which is something that states have been hesitant to adopt. And in fact, many states have been waiting for the declaration by the International Court of Justice of apartheid, which has happened today very clearly. The third article that was cited today is about apartheid, basically, and racial segregation. So now, if anybody has doubts, despite all the great reports that have come out of different civil society organizations, as well as special rapporteurs like Professor Lynk himself, who wrote a report about this issue earlier, then this is not now, there is no doubt about it. We have the highest court in the world saying that. This should lead our struggle to focus on the last bit of this advisory opinion, the one that has just been read and cited by Professor Lynk, that the Security Council and mainly the General Assembly should consider the precise modalities and further action to bring to an end as rapidly as possible the unlawful, etc. Right? So this is what we need to do right now. And there have been a number of initiatives. One of them was to reactivate the Apartheid Committee in the General Assembly. The Apartheid Committee, which worked against the apartheid regime in South Africa, worked very actively on advancing sanctions against the apartheid regime. Yes, the Western world resisted this for a very long time, but at the end of the day, when it was clear that the world was united against racism and the world was united against apartheid, the Western world followed. Yes, the Western world does not lead a struggle against apartheid and racism. This is something that we have gotten used to. However, it does follow. The countries of the global south have the obligation now to carry all the elements, the positive elements that came out in this decision, and to turn them into action. And this action can be nothing but sanctions now, because if we just keep using the language without any specific action that is going to mean that Israel will lose if it continues these violations, that third parties like other states that are supporting this occupation and apartheid, companies that are supporting this occupation and apartheid are going to lose something if they continue to do so, then this machine will continue working. So that's the main goal now that our diplomacy should focus on. I think it is much more important than focusing on further recognition of the state of Palestine or UN membership. I know that these campaigns are also very active. I don't think they are in our priority. I think our priority is to end the occupation. Palestine is a state. It is recognized as a state in the United Nations, in other international organizations, and in the International Court of Criminal Court as well, which ruled that it's a state. So there is no question now about the statehood of Palestine in law. The question is, how is this state going to be able to advance the rights of the Palestinian people to be free of apartheid and free of occupation, and for the refugees and internally displaced persons to return to their homes, and for everybody who has lost land to have the land back as the court ordered today. People who have been tortured and are still being tortured will be free from torture and will be compensated for all the violations that they have endured. These are the real questions now, and this is what our diplomacy should focus on.
Thank you, Munir. I will ask the same question to Saleh as well. And you mentioned, Munir, something about the priorities and in the sense that it should be ending the occupation. Saleh, how do you see this happening in light of the BDS action?
Yeah, so building on Professor Lynk's and Munir, yes, diplomacy, but also it is time to maximize our grassroots and civil society pressure on all states, on the United Nations, and on regional bodies. And what we want to see is an immediate imposition of a comprehensive military embargo on Israel. This includes the export, import, transfer of weapons, military equipment, dual-use items, etc., and also to end all forms of military cooperation. That includes, for example, training or joint research and investment. We want to see an imposition of lawful targeted sanctions, including diplomatic, economic, financial sanctions. We've seen some of those already. Turkey has cut all trade with Israel. Malaysia has closed its ports to Israeli ships and ships destined to Israel. The Maldives had moved legislatively to restrict the movement of Israelis. Colombia has suspended coal exports as well as diplomatic relations and so on. And so we have a start. This decision should give us more, as Professor Micheal Lynk has put, more wind in the sail of this. But we also want to see an immediate end to all forms of complicity with Israel's illegal military occupation, now as the court confirmed, apartheid and brutal genocide in Gaza, so that this 76-year-old regime of settler colonialism and apartheid is dismantled. And this includes media organizations, academic and universities, corporations and so on that are complicit, and this complicity is at the heart of why we have this regime persist for so long. We also, as Munir said, this is the time to reactivate the UN Special Committee Against Apartheid. As Munir was saying, it played a crucial role in bringing down apartheid in South Africa. We want to see the same thing happen in Palestine. But also, Israel's, we've been hearing also now from UN experts and special rapporteurs, Israel should be suspended from the United Nations. Not only for the ongoing genocide that is taking place, the ethnic cleansing and the apartheid, but also for these systematic attacks against the UN and UN facilities and so on. And finally, and this is something that now is also being monitored, is that we want Israel to be suspended from the Olympics, from FIFA, and all such international regional fora and events. And we know that FIFA is now considering a request to suspend Israel's membership. We hope that, and this is something indeed that civil society should be using, this ICJ advisory opinion to further this cause. So we have it laid out. The demands of the Palestinians are clear. These are the demands of the Palestinians: the military embargo, the sanctions, the suspension of Israel from the UN and international organizations, and for the special committee against apartheid to be revived, so that we put action to these rulings. This one, the advisory opinion, the ruling of provisional measure in the case against Israel for committing genocide, and also the 2004 ruling on the apartheid wall. So just to conclude here, yes, as Munir was saying, diplomatic pressure, but really it's only through people power, the grassroots civil society mobilization, to put pressure on states, to end their complicity, to impose sanctions on Israel, that we really can see the change that we want, the justice and freedom for Palestinians and others around the world.
Thank you, Saleh. Basically, basing my question on Saleh's conclusion that Israel has to be expelled or unseated from the United Nations, I think Dr. Francesca Albanese, Francesca is here with us on the call, has commented on this, and I think the UN Special Rapporteur on Housing, Mr. Raja Gopal, as well, mentioned that there can be no way forward without unseating Israel from the United Nations, the same way that South Africa was unseated during the apartheid mandate. Directing this question to you, Micheal, do you think there is a way for Israel to abide by this resolution and the others while having a seat at the United Nations and the other legal fora such as the FIFA, so on and so forth?
Thank you for that. I mean, in this actually, you're exposing an area that I don't know the answer to. If a country can be unseated by a ruling of the General Assembly or by a ruling of the Security Council. If it is the Security Council, then it's obvious that the United States will continue to offer a diplomatic shield to Israel with respect to its status at the United Nations. I mean, I suspect whether it's a Democratic president or a Democrat president or a Republican president that's in power in 6 months' time, as the discussions with respect to the implementation of this ruling become clear, but they will do everything they can to try to dilute and sideline the implications of this ruling. Because remember, as I said before, the main steps that should be taken by the United Nations and other countries who will follow the direction of the United Nations will be coming from the General Assembly. But whether or not active implementation of those recommendations for sanctions against Israel, including its membership at the United Nations, will almost certainly be determined by what position the United States takes, and to a lesser degree, what positions are taken by governments in Europe, and particularly by the governments in the United Kingdom and France, which makes me think that, in many ways, what's the best use of our resources in terms of trying to implement this particular decision? And to my mind, it's building national coalitions at the national level to take steps with respect to reviewing and perhaps eliminating trade relationships with Israel, to downgrading diplomatic relationships with Israel, certainly to be ending weapons and military cooperation with Israel, and in turn to take steps, if they haven't been taken already, with respect to recognizing Palestine as a state and to helping to build up Palestinian civil society. I'm not saying we shouldn't look to issues with respect to having Israel lose membership in the United Nations or in major sporting events like the Olympics or FIFA, but I think there are other steps as well we should be taking with equal energy that will actually wind up raising the cost on Israel militarily, economically, and politically and diplomatically for maintaining this occupation and for continuing to defy the direction of the International Criminal Court.
Thank you, Michael, for that. I'm trying to have Noura Erekat as well join us as a speaker. She's with us on this call.
Hassan, can you hear me?
I can.
Okay. So,
Yeah.
thank you.
So yeah, I would love to hear more from you, Noura, about this particular detail as well.
Hi, everybody. I'm listening in like everyone else here on behalf of Jadalia, which is co-sponsoring this excellent panel. I wanted to just shed some insight on this issue of unseating in law. When the initiative was taken in 1974 to unseat South Africa, there was a tremendous amount of uproar, especially from the United States, Britain, and France within the Security Council, who felt like it was too extreme and obviating the possibility of negotiations with the apartheid regime. So this should sound very, very familiar. In response, at the time, Abdelaziz Bouteflika, the foreign minister of Algeria, had taken the helm of the General Assembly, and in his capacity as president, actually amends the rules regarding whether or not a state can be seated, thereby creating a distinction between membership, UN membership of a state, which remains within the plenary power of the Security Council. Only they will be able to determine whether or not a state is a member, which is both what Professor Lynk is highlighting for us, that the US would be in imposition in this moment, but also highlights why Palestine as a state, its formal membership was not recognized within the Security Council. But this is distinct from the ability to unseat a state, which is within the purview of the General Assembly. What would then be the obstacles if the United States is not the primary obstacle, if it's not in the Security Council? It's a regional and it's a political question. When it was attempted to unseat Israel using these very same mechanisms between 74 and 75, Egypt emerged as the primary objector to unseating Israel because it was then in negotiations to recoup the Sinai through diplomatic means. And so we see today that there will probably be very similar obstacles, even amongst who would be regional allies, specifically as demarcated by the Abraham Accords, and what that would mean for these very states then to engage in this kind of offensive strategy. So as Saleh and Munir and others were highlighting, this will remain a very political question. It's not about the means or the ability. It's certainly a possibility and within the capacity of the General Assembly, but it will require a tremendous amount of political will. Thank you. I'm off.
Thank you, Nora, for your reflections on this. I'm wondering if Francesca would be able to talk as well at this time. If not, I will ask Munir about one particular detail that was mentioned, which is the Palestinian right of return. What do you make of this? And what do you think should be the next step in this discourse? The formulation of the comment on the right of return, oral advisor opinion, like as far as I heard the oral hearing of the advisor opinion, I did not read the text yet. It did not make a specific reference to the geographical limitation of that. What do you make of this, Munir?
My initial understanding of this, based on what I heard today, has been that the court was asked about different policies that Israel has been conducting in the occupied Palestinian territory since 1967. And one of the elements that this court has tackled has been forcible displacement, the transfer and deportation of Palestinian civilians within the occupied Palestinian territory or across, to outside the occupied Palestinian territory. This has been very explicitly found as an illegal act that was done by Israel. Article 49 of the Fourth Geneva Convention was cited by the judge, and therefore the reparation for this element, for this violation, for this crime, actually, it is an international crime, it is a war crime if it happens to one person, one civilian in occupied territory, and it's a crime against humanity if it turns out to be systematic or widespread. And we know that it is both. It is systematic, it's widespread, it's happening on a continuous basis. It's an important part of the Israeli apartheid regime that has been installed in the occupied Palestinian territory. So the right of return that was mentioned today, to my understanding, is limited to the question that was posed to the court because of the scope of the question. The scope was asking about 1967. So the court said that people, Palestinian civilians who have been displaced since 1967 until the current day, must be allowed to return to their homes. And it was in a way linked to the settlements as well. Now, this does not mean at all that those who have been displaced since the Nakba, since 1947, do not enjoy the same right, obviously. The right of return of refugees and displaced persons had been established way before 1948. It had become customary prior to the Nakba in 1947 to 49, and therefore the right to return is certainly applicable also to all Palestinians from the areas on which Israel claimed its sovereignty after the Nakba of 1948.
Thank you, Munir. And I got a message from Francesca. She won't be able to join due to her connection. It's not very strong, but she conveys her gratitude to all those who worked on bringing this to light back in 2017. Everyone who has contributed to this to happen. This has to be. She is telling us that we should not leave any venues unattended. This has to be one of them, and hopefully some action would come out of this advisor opinion. That's what we should be working on. I basically rephrased what she has mentioned. I have one more question for you, Micheal, and then I will be concluding with Saleh our conversation. The question is about restitution. Restitution is such a vague and general term in international law. It can include, it's a very big umbrella of action that could be in a way restorative, not necessarily just punitive or restitutive in that sense.
Yes, but it does have sufficient grounding in international law, and particularly in previous decisions of the International Court of Justice, and also in various treaties that have ended wars or occupations, that we know we have enough guidelines, we have a solid enough framework, I think, in international law to be able to explore in depth what restitution, including compensation, would mean both collectively for the Palestinian people and individually for Palestinians whose economic livelihoods or whose physical well-being or mental well-being have been adversely affected by the Israeli occupation. When we can imagine, we're talking about millions and millions of people. I think this is a great question for both international lawyers as well as economists to want to be able to work on, to be able to determine what a framework for compensation has been. One prominent economist, the Lebanese-Canadian economist Atif Kabursi, has done a study probably 15 to 18 years ago, where he estimated the amount of compensation that Israel owed to the Palestinians for its breaches of international law. And he set out a fairly detailed framework for how to wind up assessing that. So I think prior work has been done. I think it's within us to begin, I guess, the collection of international lawyers and economists who can work on this particular issue to start determining what the modern framework would be for assessing this, and B, starting to put numbers together that would wind up assessing what the total bill may wind up being. I suspect in order to get traction for this, we'll either need specific resolutions coming from the Security Council, from the General Assembly. And I know the General Assembly in recent resolutions has actually talked about restitution and compensation. So the legal basis is there, and I think all we need to do now is put the wheels in motion to start coming up with a viable test and putting the minds together who can wind up determining this.
Thanks a lot, Micheal. We are coming to an end to our discussion, but I would like to hear a final message from Saleh to conclude this conversation. It's a 1-hour conversation that hopefully we will convene every now and then to have reflections on the international legal updates relating to Palestine. Saleh, this is a historic moment, as we mentioned, in the history of the Palestinian legal struggle. What's next? You have mentioned ending the occupation through isolating Israel from institutions, from international legal fora, the FIFA, the Olympics, so on and so forth. How will the BDS translate this advisory opinion into an action? And a message from you to conclude this discussion will be much appreciated. Thank you.
Thanks, Hassan. Look, courts alone can never deliver justice. As I said, the deliberate disregard of, for example, the ICJ's rulings on Israel's apartheid wall in 2004, Israel's genocide in 2024, this disregard exposes the colonial foundations of the system of international law. And the Palestinians, us and the people of the Global South, perhaps more generally, know too well that justice will not come from The Hague. Only people power and advancing and maximizing now the boycotts, divestment, and sanctions can force the US, Israel access to stop the genocide, to dismantle Israel's 76-year-old regime of settler colonialism and apartheid, so that we Palestinians will be able to exercise our inalienable rights of self-determination, of the right of return. It's a milestone. Yes, it's the action that we take. It's how we use it. Israel's impunity must be put to an immediate and complete end now. Hopefully, this is the start.
Thank you so much, Saleh, Micheal, Munir, and Giulia. In the name of Jadaliyya and Law for Palestine, I would like to thank you all for this very rich conversation in 1 hour. Apologies for the technical issues in the beginning. This is the first time that we hold this conversation over Twitter, but hopefully we will proceed and continue to have this conversation further. This is but the beginning. The advisor opinion opens new doors for legal action that hopefully will change the reality on the ground. And at the end, we're not talking about a big moot court. We're not talking about a general theoretical legal debate or discussion. We're talking about people's lives. We're talking about people's blood, people's daily suffering. And hopefully, with everyone's effort, this will change eventually, the same way it changed elsewhere in South Africa and all around the world. Palestine will no longer be an exception. Or what Ardi, Professor Ardi calls the Palestinian, the international legal subalternity of the Palestinian cause will not continue to proceed. Thank you so much, everyone. Have a lovely day ahead, and talk to you soon in new conversations.